Panel. It's my pleasure to have us discuss the new frontier in raising capital after the Jobs Act. So the keynote was a perfect segue to our discussion. I'm really happy to have this fantastic panel here, and I'm just going to do some very quick introductions. I think a lot of you know these individuals, but just in case not, I think it's worth just a few minutes. Well, first, we have someone who is not physically here, but is tied in on the phone. As you hear, his saga was sad and tragic, but he's kind enough to be here. And that's Keith Higgins, who's the Director of the Division of Corporation Finance. We're happy to have him join us by phone. He became the Director of the Division of Corporate Finance in May of 2013, having taken that role after being a partner at Ropes & Gray, where he had very substantial experience in securities and corporate law, having advised a very wide range of clients. He is the past chair of the Federal Regulations of Securities Committee of the American Bar Association. No surprise, Phi Beta Kappa undergrad, master's from University of Virginia, and a law degree from Boston University School of Law. I can't harass him because that's an okay law school to go to. I will be harassing a couple of other people in just a moment, however. So we're really happy to have Keith with us today. In a little bit of out of order, I'd also like to introduce Miriam Rivera, who is a very frequent contributor to Rock Center events and issues, in part because she is such an experienced and varied business person, lawyer. She is the only person I ever get to introduce who has four degrees from the right school, which is to say Stanford. Bachelor's, master's, JD, and MBA. And I think you did that all before you were like 26 or something crazy. So we're really happy to have her here. She is the co-founder of Ulu Ventures, where she is a managing partner. Her roles have recently changed, and she's doing lots of other things. I'll let you expand on that. But she is, I dare say, famous for her time at Google, having innovated as a lawyer. Lawyers can innovate in a lot of ways, and really contributed fantastically to their kind of current success. And not least of all, she is a fantastically successful investor and advisor and encourager of a wide variety of entrepreneurial activity throughout the community, including, I think, with a lot of the target populations we worry about not being as active in venture capital and other areas. So we're really very happy to have her. I'm also happy to have Carlos Vasquez with us here today. He's senior counsel at the Division of Enforcement at the SEC. He graduated from the wrong law school, Harvard Law School, and he's on the Jobs Act task force with the SEC, and he's going to both contribute and also, I think, make sure that Keith contributes in a positive way. And then my final introduction is my hardest one of all, because it's hard to introduce someone who everybody already knows, even just on site. So as some of you know, when I do introductions, I try to dig up stuff that most people haven't heard, at least recently. So I'm happy to introduce Larry Sonsini. He is often referred to as the Larry Bird of Silicon Valley. And this is a quote that I recently ran across: "The go-to guy when you need the thing to work, the ice in his veins, blue-collar scramble for the ball, great teammate, no ego, championship caliber guy." The guy that Fortune magazine once called the most powerful man in the most crucial sector of the American economy. I can only fault him from also graduating from the other wrong law school across the bay, but I will note that he does periodically teach securities law at the right law school, which would be ours, so thank you for that. So with this panel, I think we're just going to kind of jump straight in, and I have an opening question, which is kind of introductory for the concept, and that is maybe Larry, you first, and Miriam, if you want to join a bit. How have recent policy changes, such as the Jobs Act, altered the capital raising landscape for pre-IPO companies in Silicon Valley? I mean, is it really all that we think it is, and has it changed things? What do you think?
It's definitely changed things. It's really improved things. We've gone through an interesting period where capital has become very abundant and at different layers. Now you have angel investors, micro VCs, venture capital firms, growth equity, private equity, and even large institutions that are coming into private placements. So we have an abundance of stratified capital. And the Jobs Act, I think, has made a major contribution in a couple of areas. First of all, expanding the number of shareholders you can have before you become a reporting company. A major change. 2000, provided that no more than 500 are non-accredited. Certainly, the emerging growth company ramp to IPO has been terrific. You can now test the waters. about an IPO, which you could not do before. You can talk to qualified institutional buyers and accredited investors. You can have analyst participation in the distribution process, which we couldn't do before. You can file confidentially, quickly, to get input from the staff before you go. And certainly, you have less disclosure in terms of the quantum and quality of your financial statements, less compensation disclosures, say on pay. So the ramp to IPO has really created great flexibility. And quite frankly, it was a very creative move. And I applaud the SEC for it. And then you have, of course, what we're going to talk about today, the ability to do basically private offerings still using general solicitation. The concept of general solicitation has been at the heart of the exemptions under the Securities Act ever since 1933. It always has been a very, very difficult hurdle because once you had a general solicitation, unless you were doing intrastate offerings, you basically were losing your exemptions. No matter the quality of the offerees, no matter the quality of your disclosure or the quality of the purchasers, the SEC has taken that off the table with 506C. But there are trade-offs, and we're going to get into that, and it'll be great to hear from Keith on this. You've heard Commissioner Stein, what we can do with Regulation A+. I'm a bit of a fan of Regulation A, and my first offering I ever did in 1967, believe it or not, was a Regulation A offering. It has value. It hasn't been used. As Commissioner Stein indicated, it's been on everybody's shelf. But now with Regulation A+ coming on the horizon, quite frankly, I see that more exciting than crowdfunding. And then you heard about crowdfunding, which I think is one that we got to debate. I happen to have a lot of concerns about it, and we ought to get into that. But through all of these changes, I think it's important to note that the fundamental tenet of the securities laws, that sunshine is the best disinfectant and electric light is the best policeman, has not changed. And all of the changes, that has not changed. Investor protection, the anti-fraud rules, the quality of disclosure is still there. And that has to be balanced as we loosen up these rules and we get more people involved in the securities business that is a risk business who will have less ability to fend for themselves. We've got to weigh that risk. So I'm very encouraged, very excited, but we've got some debates.
Before I jump to Keith to expand on the changes to general solicitation, I'd like maybe Miriam, you're on the other end of the spectrum to a certain extent, right? I know you span quite a bit of it, but can you comment with what you're doing every day, kind of the earlier stage companies, what's going on?
I don't really think that the new allowance for general solicitation has really changed a lot at kind of the seed stage companies where I invest. And I would say that some of the improvements in solicitation have occurred because of the incubation that is occurring in a lot of accelerators and incubators in Silicon Valley. So I would say that general solicitation was much more common, frankly, in the past, and has become less common as the companies going through these incubators are getting more educated about securities regulation, about what is a general solicitation, do they really do it. A lot of the incubators also prohibit the companies from talking about their offerings as opposed to demoing their products. And so I've seen less general solicitation more recently than previously. I also think that the majority of companies are still engaging in private offerings with accredited investors without general solicitation, and they are continuing to do it in the ways that have historically been done through referrals, through people they know, through faculty on campus that suggest they talk to particular people, and that it really hasn't changed that much what you see. There's still what I would call inadvertent general solicitations as you go through different kinds of events, and the less experienced companies, I think, are more likely to do that. But in general, I've actually seen improvement.
And I think we're going to get into some examples of the inadvertent and maybe expand on what is more possible now as opposed to in the past. But before we do that, Keith, hopefully you can hear me okay. We know that one of the big impacts of the Jobs Act, as Larry enumerated, was allowing companies to raise capital using general solicitation without necessarily having to register with the SEC. Do you mind taking a minute and describing the old prohibition against general solicitation, and then maybe briefly what is now truly allowed under the Jobs Act and Rule 506C?
Yeah, no, I'd be happy to. And interestingly, I've got the live feed up on my PC next to the telephone here, so I'm able to actually see and feel as if I'm part. So,
hello, excellent.
Apologize for not being there in person, but at least I'm able to view you. So yeah, for years, well, it's always been the case that you either have to register a securities offering or you need to find an exemption, and typically the exemption that you'd find would be an exemption for a transaction not involving any public offering. And one of the hallmarks of not involving any public offering was the absence of any general solicitation or advertising, so that in order to qualify as a private offering or a non-public offering, you could not engage in a general solicitation or general advertising. And we'll talk more about what that is. Under Rule 506, which is a safe harbor under the securities laws for private offerings, issuers could raise an unlimited amount of capital, unlimited number of accredited investors, and up to 35 non-accredited investors who were nonetheless sophisticated about investing. And accredited investors, most of you know under the SEC rules, are investors who meet minimum income or net worth requirements. And 506 really has been the far and away the most widely used exemption from registration, but at least until 2013, you couldn't do a general solicitation. Fast forward to 2013, so for 80 years, the securities laws lived without being able to generally solicit in a private offering. Along comes the Jobs Act and removes that, it directs the SEC to adopt rules to remove that ban on general solicitation. And I like to think of it in terms of, and I'm sure that this will sound a little bit silly, but you know, the old expression, sticks and stones will break my bones, but names will never hurt me. The notion was that offers themselves wouldn't hurt. It's only the purchases that would hurt. So the purchases were the sticks and stones. The offers were the names. And what Congress directed us to do was remove the ban on general solicitation so long as only accredited investors purchased, and they added on this wrinkle that I think has caused a fair amount of consternation. The issuer has to take reasonable steps to verify that all of the purchasers are accredited investors. And that's one of the slight differences between the existing law and the new law under the Jobs Act. And so that's the landscape. The Commission adopted rules that became effective in 2013. In September 2013, the gloves were off. We haven't seen a lot of offerings filed as general solicitation. Of the 506 offerings that have been done for which Form Ds have been filed, about 90% have been for regular old 506B offerings, whereas only 10% have been for the newer general solicitation. But that's the notion, and of course, general solicitation is a concept a little bit like maybe it's a little more defined than obscenity, but you sort of know it when you see it. But there isn't a clear definition, and I think that's where some of the uncertainty lies, which I'm sure we'll get into as we talk further during the course of this evening.
So now we have the history, framing, and what we think is in place now, but we have these ambiguities and potential consternations and risks. So maybe, Larry, could you say what would be your advice to companies right now if they were in fact going to consider general solicitations?
Well, as Keith indicated, right off the bat, we have to recognize that if we're going to engage in the general solicitation, we've lost optionality on almost any other exemption. The private placement exemption should not work with a general solicitation. 506B, 505, the other rules fall away. So the first question is, let's be sure that we know what we're getting into. The other thing to remember is we regulate offers of securities. And the question is, what is an offer? And we've got to realize that a general solicitation could involve an offer of a security right off the bat. For example, you have pitch events where you talk broadly about startup companies. You have demo days where you talk broadly about products and services. Those events could be viewed as conditioning the market for an offering. And the SEC has had a long-standing sound policy that conditioning the market for an offering is itself an offer of a security. So now you have an offer out there. So remember, if you don't have an offer, it doesn't matter if you have a general solicitation. If you do have an offer, general solicitation matters a lot. Then the other thing that I think you have to keep in mind are what are the trade-offs? What are the advantages and what are the disadvantages of it? And I think it's important to recognize, of course, that the general solicitation is only one step in the process because you have an obligation you inherit. And the obligation is you lose optionality here. You don't have a fallback to another exemption. And a condition to doing a financing under 506C, the general solicitation permission, is that you have to take some steps to verify that your purchasers are actually accredited, and we're going to get into that. So you have a job to do, and it may increase cost. It may increase administrative work. I think also you have to realize that there's no exemption from the anti-fraud rules. So the wider the net you go, notwithstanding the fact that your ultimate purchasers may be accredited, you haven't exempted yourself from disclosures of material information. And I think there's always a trap. I have some companies that think about 506C and really think the gloves are off. I can get this offering done broadly without registration, and they're really not off. So I think these are kind of the trade-offs you have to weigh about it. It really is, I think, a very good rule and could be terrific, but I think you have to go into it recognizing you're going to have to check the box if you're going to use it. You can't be coy about it, and you're going to lose optionality in the process.
And so to follow up on that with Miriam, you mentioned a moment ago that you have seen some companies that value using general solicitation. Beyond just asking whether or not you would recommend it generally, what about framing yourself as the VC in that story? Would you have concerns with investing in a company that raises funds with general solicitation generally? Does that raise a flag for you? Does it make you engage in different type of diligence? What happens?
I would, but not because of the category. It's more because it gives additional hurdles that companies have to meet in terms of record keeping and diligence, and anybody who's really worked with startups would be really rightfully suspect that those are actually going to be done, and that the documentation is going to be preserved appropriately. And so from that point of view, I would have concerns about whether that offering could be later subject to rescission, and whether my investment is going to be an actual investment. So depending on how well regulated these are and whether or not there'd be more investigation or enforcement of offerings that actually put a Reg D 506C category, I'd still be a little bit more suspect of it.
And perhaps if I could just riff off of what all the panelists have said so far. The San Francisco Regional Office obviously takes this issue very seriously because of the potential for its use and misuse in our region. We have several members of our staff that are dedicated to, that are part of the Jobs Act task force in the Division of Enforcement. We also have people on the IA and the BD side that are looking for that. And as Keith mentioned, there are filing requirements in terms of Form D where you're supposed to indicate that you're using 506C. Our Division of Economic and Risk Analysis recently ran a report, which I think is on our website, that looked at Form Ds filed between September 23rd, 2013 and September 22nd, 2014, and found that there were 1,697 new 506C offerings in that period, raising $15 billion. So this is obviously a big market. Now, in comparison to the old 506, which is now 506B, there were 18,997 offerings and $465 billion raised. So it's still a very small chunk of the market, as Keith mentioned, but it is one that we do have to worry about because of the general solicitation potentially bringing in a lot more people who shouldn't belong into that offering. So one of the things that we do is we work with DERA and a group called Circa to data mine the 506C offerings in our region and look for ones that we think might be problematic. And we have opened investigations based on that. And we are specifically looking at the issue that we're going to talk about next, which is the accredited investor verification process. But we're also looking for flat-out fraud because back in 2013, we actually brought a case against a company or firm that was gun-jumping the general solicitation rules by saying, we're going to raise a little bit of money now, and we're going to make huge returns. I think they were promising somewhere between 500 and 1,300% gains over 10 years, because we're going to piggyback on the general solicitation when it becomes available. So 21 investors and $400,000 later, we find out that the person is actually using the money in Vegas and paying for his Beamer and going on vacations, and it's just the outright fraud. That's also something that we have to consider in this field.
On that happy note, Keith. Keith, did you want to add something? I think I heard you say something.
Let me jump in, and I assume that somebody gave the disclaimer, the obligatory disclaimer for SEC staff, so I didn't need to repeat it. But as my folks always tell me, clearly I'm only speaking for myself in any venue. But on that point, the notion of general solicitation has always focused on whether or not the company had a pre-existing substantive relationship with the person to whom it was soliciting. And, that pre-existing substantive pre-existing had to be prior to the time that it made the offer. And substantive really focused on the fact, was there some basis that the company had to believe that the person to whom it would be making an offer was the kind of person who had the requisite sophistication in business and financial matters to be able to evaluate. It didn't necessarily mean that the company needed to know right out of the box that the person was an accredited investor. But there had to be a basis upon which you would conclude, yeah, this is the kind of person who would be interested and would have the ability to evaluate an offer of securities. What we're wrestling with now as people try to, the interesting thing about general solicitation, of course, is that nothing has changed about the definition of general solicitation. What was a general solicitation before the Jobs Act continues to be a general solicitation after the Jobs Act. It's gotten a fair amount of heightened awareness about it because people all of a sudden have said, oh my gosh, changed as a result of the Jobs Act.
And in fact, let me maybe drill down on that because it sounds like the inadvertent or accidental general solicitation, therefore, is going to be more relevant. I'm scanning the room, and I don't know if you can see from this angle, but there are definitely some entrepreneurs in the room, I think. And so let's go back to this. We mentioned it, but let's go back to this promotional event / demo day. And can you give us more color around what the SEC looks at and then says, oh, that's fine, it's a promotional event demo day, versus saying, ooh, wait a minute, that might be crossing the line? What can an entrepreneur
exactly. I
think
think
about?
If you look, and we actually had some old no-action letters that we've actually encouraged people if they're uncertain and want to come talk to us about whether we'd provide some guidance on current affairs. But we had some old no-action letters that dealt with venture fairs, which dealt with these types of events where entrepreneurs would get together with people who were interested in investing in companies to where they could sort of kick the tires and see what the companies were doing. Into the event that they had a reasonable basis for thinking were the kinds of people who invested in, early stage companies, had the sophistication, the financial and business expertise to look at it. That was not something that I think, at least from Corp Fin's standpoint, I can't speak for my friends in enforcement, Carlos, but at least from Corp Fin's standpoint, that was not the kind of situation we were concerned about. This was not the ad, having a seminar at the local Holiday Inn Express, inviting people to invest in something, a sure shot proposition that was not, that they couldn't lose their investment. So those are the kind of things that Carlos and his folks are after every day of the week. Situations where companies were sort of explaining their business model, their technology, their promise, their markets, and talking about their capital needs, what it was going to take to get to profitability. Those, although probably back to what Larry talked about, would be conditioning the market for an offering of securities. We're sort of on the bubble of whether there was an offering or not, and so long as they were made to people who had some relationship to the sponsor of the event, that it wasn't something held at the Moscone Center where everybody could come in, but it was people who were coming in that did this kind of thing. Those are not the sorts of events that caused us to have a lot of heartburn. Is that helpful at all, Dan?
That's very helpful, and I think I'm going to allow Carlos to add divisional nuance to this. But before you do that, I want to put out a little piece, an extra fact that maybe we can all think about, talk about. So I'm not quite sure what you're going to say about this kind of controlled audience, but the modern twist on that is that in that controlled audience environment, you're the CEO, you're pitching, you're getting these great questions from what are probably perfectly qualified investors, and your head of marketing is sitting in the corner, and she takes a photo of you answering the question, leaning forward, and she tweets, hot startup getting hotter, everybody clamoring for a piece, right? And they tweet that up. And so I want to add that kind of social media twist to this, which is, Miriam's nodding because she's probably seen that happen in real time, right? And so what does that do, even if we were comfortable with the first version? So Carlos, maybe take us through both.
Let me go old school on you, back to 1995. Keith was mentioning a no action letter, and for those of you who don't know what that is, basically somebody writes into a division at the SEC and says, we're planning to do this, we're planning to follow these rules, would you please not sue us? And the division will write back, if you do this, as you say, we will not recommend enforcement action against you. So it's the no action. So back in 1995, Michigan Growth Capital Symposium wrote in to the Division of Corporation Finance and sort of outlined what they wanted to do. And it's very similar to a venture capital fair. And sometimes what the Division of Corporation Finance will do is sort of pull out the facts that they thought were maybe the most relevant out of the longer letter and say, as long as you're really doing these, that's, we're not going to recommend enforcement action. And in that particular letter, which is May 4th, 1995, once again, the Michigan Growth Capital Symposium, they looked at the fact that they were only bringing in a limited number of companies, I think 20 to present. The audience was sophisticated. They were publicizing through targeted mailings to known accredited investors, as well as very limited general advertising in the Venture Journal. No specific financing details were part of the presentation, and no private placement materials are distributed there. So those are some of the factors that were looked at back then. And from there, you can extrapolate what is it then that you're doing if you broadcast it, if you tweet it. You can commit fraud with a tweet. I think if we haven't gone there already, we're going to get there soon. So I think you could sort of look at some of those general principles and then say, what are you doing with social media, and are you still keeping within that limited audience, or have you just blown it out to the entire world?
Carlos, can I ask you a question?
Sure.
Now that we have 506C, do you think that the staff is going to tighten up the concept of general solicitation for purposes of 506B, where you're not allowed to have general solicitation, or not?
I think, it's interesting because occasionally we go to one of these companies that's filed for 506C after we, done our data mining, and they're like, whoa, no, we checked the wrong box. We are not generally soliciting. That was a complete mistake. We hired the wrong, So I think I think we're aware of that issue. Whether we want to tighten it in 506B or just kind of focus more in 506C, some of that just becomes a resource constraint because with the thousands of Form Ds that are filed, we obviously just can't go after all of them, but I think it's an issue that we'll look at.
And Carlos, let me jump in too, because I know this is stuff that you guys do, and Larry, things like affinity fraud are really bad, and this is where maybe it's, is it a general solicitation when you go to your neighborhood club, where you sort of generally know the people, but you don't have a clue as to what their financial wherewithal is, their sophistication, their financial and business expertise, and you're trying to sell them some securities. That's a problem. That is a huge problem, and it's a much bigger problem than is the situation where, you got a bunch of tiers of venture capital firms coming in to talk to 20 companies that are looking to introduce themselves to the venture capital community.
Yep, exactly. I think a good thing to keep in mind is, let's go back to old school, the private placement exemption. It's still there, a transaction not involving a public offering. And there are several elements that came out of the SEC no action letters and case law about what that is. And in the private placement exemption, it's really about the offerees and not the purchasers. It's the number of offerees you went to, the sophistication of the offerees, the ability of them to fend for themselves. The concept was you didn't have a public offering if you went to a large number of people, provided that you had a basis and a relationship to demonstrate that you knew that they could fend for themselves. They had the knowledge and expertise to assume the risk of the investment. What this staff has done in the Jobs Act, it's kind of given you with 506C the ability to throw all of that out. It's not about offerees. They don't even count the number. It's not about relationships. It doesn't matter. But it comes down to now you're on the hook to verify the purchaser as being accredited, and once you go down the path of general solicitation, there's no way of looking back, and the old rules now are still there. So it's not for the faint of heart just to do it. And I think that I'll go back to these pitch events and these demo days in the country club. There's a lot of conditioning of the market going on by entrepreneurs unwittingly making offers to sell securities because social media is driving that, the web is driving that, these events are driving that, and it's something that we have to continue to pay attention to.
Let me ask Miriam a follow-up on that, which is, in light of this inadvertent activity, do you think entrepreneurs have become a little bit more sophisticated? Are they more aware of it? Or are they just excited about the potential but lack kind of a grasp of the details? And even if they know the details, are they going to follow up in the way that you mentioned before?
Well, I do think that a lot of the ones that are doing the demo days in a specific setting like an incubator, those incubators are offering education. I mean, how many lawyers from Wilson would be volunteering to go to StartX or some other incubator to say what the securities regulations are around general solicitation? It's very common for very good professional counsel to be speaking with these young companies and giving them advice about what not to do. Now, I will tell you that you'll go to a demo day and then someone will say, we'll be raising. And I don't know why they would, because I think they have actually been trained. I certainly think that everyone understands that if you're in an incubator, you're likely to be raising in the next 6 months to a year. So there's some amount of conditioning that I tend to believe is relatively going to happen regardless of any training that you provide. But I do think that a lot of the incubators have special event nights where they call them either VIP nights or the mentor nights or other things where the people that are invited in that room are specifically more sophisticated investors. And I hope that the activities that are done between the audiences that they invite to hear the demos are scripted more carefully. I also see them trying to shorten the amount of time, so the fewer words said, the fewer mistakes can be made, and I think that's all good.
Carlos, do you get invited to those events, or is that?
I was going to tell you, you often don't have to worry about SEC enforcement actions rising out of those because we're never invited to those events. And I will tell you that to the extent we are there on SEC business, we do have to announce ourselves, and so there's going to be fair warning.
Got it. And I think another trap that happens is an entrepreneur that's going to maybe do a demo day or a pitch event may think that what I'll do is I'll make a number of cold calls to find out whether you're accredited or you're sophisticated so that I can get a number of people there and yet still have the option to say it was a general solicitation. And I think the staff is very clear on this in no action letters that these cold calls, even to sophisticated investors, probably blows the general solicitation off the bat. So how to manage a general solicitation if you're going there or if you're not going there is critical.
I'm going to shift gears a little and get us on to the new requirements for verifying accredited investor status. I think, Keith, I think we're starting with you on that, and I might turn to Larry a little. So what are the new requirements for verifying accredited investor status? And then I think we're going to talk about the risks if you go down that path. Keith?
Sure. Under 506C, the new rules that permit general solicitation, the issuer is required to take reasonable steps to verify that the purchasers are all accredited investors. And what the SEC did in implementing those rules was it established first that what's reasonable is going to depend on the facts and circumstances of the particular case. And so it's really a principles-based determination that what's reasonable is going to be determined under the circumstances. Now, that's not a terribly satisfactory, bright-line litmus test that you can use. The thought being that if Warren Buffett is investing in your company, you probably don't need to do a lot of diligence to establish reasonably that he's an accredited investor.
I still make him sign something just so I can get his signature. But go ahead.
Right, but the interesting thing is under the old rule, where you were selling to accredited investors, the definition of accredited investor says you either have to be one of these people or the issuer has to have a reasonable basis it reasonably believes that the investor comes into one of these categories. And so even under 506B, you have to have a reasonable basis. And I'm not sure there's a whole lot of daylight between what's a reasonable basis for considering someone to be an accredited investor and what are reasonable steps to verify. I think that you need to, to have a reasonable basis, I like to say you can't rely on naked self-certification where someone walks in off the street in response to a newspaper ad and signs a certification that says, I'm an accredited investor. I don't think that works under 506C. I don't think that works under 506B. And so what we said in 506C, because people wanted a little bit of a bright line, said, look, we'll give some safe harbors. Tax returns, that'll establish income. Brokerage statements, et cetera, along with a credit report, that'll establish net worth. You can even have an attorney or an accountant or a broker-dealer or investment advisor certify your status as an accredited investor. Those are safe harbors, but people didn't like the safe harbors. They focused on them and they said, gosh, that seems onerous. But remember, those are safe harbors, that you don't have to do that. It's going to be principles-based and what's reasonable under the circumstances. Dan, if in your next startup you invite Larry to invest, I don't think you have to ask.
There's no way he gets me.
And, that's, again, my personal opinion about it.
Your comments have prompted thoughtful noises from Larry as you spoke, so I got to let him talk about the risks of doing this.
So I worry about this provision in 506C because the way I read it, and I think Keith agrees with me, the difference from what we were dealing with before, where we had a reasonable basis to believe someone was accredited, that under 506C, the way I read it, you can't get lucky. You can't get lucky.
Yeah, that's absolutely right, Larry. That is
in other words,
right.
under 506B, if they turned out to be accredited, that's great. And so it gave you a lot of room. But C doesn't give you that. There is a step. There is this verification step. It's a new game. And I do think that it's got some risks to it because are you going to upset potential investors when you say, look, I just don't like your answer to the questionnaire. I'd like to see your financial statements. Or I want to talk to your wealth manager. Or have your lawyer call me up to verify that you're credited. Or calculate your net worth for me. That's going to be tricky. That's privacy stuff. That's kind of like, well, I've got a lot of people looking for my money. I'm not going to put up with this. So how we do it is, I think we're going to have to, develop some systems. I do think that the trade-off for general solicitation is the verification step.
And maybe I could add a little to that, because I do actually see issues like this come across where you do have somebody who's not done anything in the safe harbor and instead is going principles-based, and lo and behold, my view of principles-based and their view of principles-based, it's not necessarily the same set of principles. And then you run into a situation where you might have somebody who, through sheer luck, Inspector Clouseau'd themselves into getting only accredited investors, but technically they didn't meet the requirements of the rule, which says you shall take reasonable steps. And if you don't take that, you may not be able to get that exemption, and you may have an enforcement action.
Yep.
There's no question about that. And Carlos, of course, you'll recall, that was explicit in the statute itself. The legislative history was very clear that the reasonable steps were a key factor in that legislation passing and the direction. So the SEC in implementing the rule didn't have a lot of flexibility. But look, reasonable people may always disagree, but at the end of the day, it's an objective standard, and it's going to be, did you take reasonable steps? And Larry, I take your point that there's risk in wondering whether or not you did.
And I think the old reasonable basis is actually facilitated so much by the internet and media that we have exposure to and easy access to. When somebody claims that they've done X, Y, or Z, you can go search on Google and figure out whether it's true or not. Has it been publicly reported in the press? Is it verified by more than one source? Does it match what their LinkedIn profile says? There's so many different ways that you can research people very easily without having actually get personal information. And I think people would rather talk about sex than money. And so asking them for this kind of information is definitely a big turnoff. I also think, for example, as an attorney, would you want to make the statement that somebody's an accredited investor? I'd rather say, I've looked at their bank statements and they meet the criteria for the last 3 months. Some factual statement. I don't know what other people are going to choose to do, but I think that it's just a higher hurdle because you essentially have people vouching for you, and again, they're going to rely on information that's provided to them, and should they be held liable if they turn out to have given false information and support for these statements?
I'm going to jump us.
But Miriam, to your point, though, I think that you can take credit for that research that you're doing on the internet or whatever publications you're doing as part of the principles-based reasonable steps to verify. I don't think that's mutually exclusive from the reasonable basis. I think it's all part of the same investigation.
Okay.
I'm going to jump us ahead a little because we've got about 10 minutes of talk left and about 10 minutes of questions and answers, keeping with our slightly adjusted timeline. So I'm going to go to you, Larry. You mentioned briefly about kind of the longer period of growth for pre-IPO companies before the IPO. This obviously invites some issues, and one of them is that the shareholders might want intermediate liquidity because it's taking so much longer, employees as well, and we'll invite Miriam to comment on that in a few minutes. But do you see other consequences for this longer pre-IPO timeline that we're experiencing now?
Well, definitely, and I think it has a lot to do with the growth of secondary markets. The combination of the new 12G rule that you can have 2,000 shareholders and 500 of them being non-accredited coupled with the fact that, companies are almost 10 years old before they're going public, as opposed to the old days. Coupled with the fact that they have a lot of ex-employee turnover that own shares. And the combination of Rule 144, which says that if you're not an affiliate, you're an ordinary employee and you've held your shares for more than a year, you can sell them without registration, without the need of an exemption. You have an inherent exemption built into the act. Then you have the company doing financings with huge valuations. We're worth $2 billion. We just did a private placement with a hedge fund that values us at $10 billion, and you got a lot of people run around and say, I'm not going to wait until this IPO. I can sell my shares under Rule 144. I've held them a year, and I got a lot of people that buy them at a $1 billion valuation, and I'm going to get out. So what's wrong with that? Well, it's got a lot of inherent problems in it. One of the problems is if you have a lot of common stock, because trading at these high valuations, remember that the high valuations usually involve a senior security, preferred stock. The common stock, companies want to keep it low price so that the options and equity incentives for employees is still attractive. Well, those valuations may go astray because of a secondary market. It may be hard to get a valuation under the so-called 409A, the tax rule that requires certain valuations. So you have that problem. Then you've got the problem of the fiduciary duty obligation kicking in. And this is really, really important. We talk a lot, and you heard Commissioner Stein talk a lot about doing a lot to be able to raise capital. Quite frankly, I've got another concern that we're not addressing, and it's hard for the SEC to address, and that is what are we doing about corporate governance today? Because a lot of the fraud is in the governance structure as opposed to the actual security offering. So I worry about that you're going to have a lot more litigation by disparate shareholders going against private companies, venture-backed, about breach of fiduciary duties, and quite frankly, venture boards are not well equipped to deal with that. They have related party transactions, they don't have independent directors, so you got exposure there. So that's a problem that's coming. And I think, therefore, this is all great for raising capital, and I'm all behind it, but I think we got to step back and realize that these consequences of developed secondary markets are fraught with potential issues. And last but not least is people are going to demand more disclosure. And ask yourself, if you permit a secondary market, recognizing there's no information out there, what obligation do you have to provide that information? You can make an argument under the Securities Act that if you're not offering the securities, you don't have any. But are you facilitating the offering? And now a lot of companies that try to deal with that are putting in restrictions that you can't sell your stock without our consent to stop a secondary market. But now you got a problem about restrictions on alienation. How valid is a restriction on the alienation of property? And the Delaware law will tell you that you can restrict transfers if it has a reasonable business purpose. What are these reasonable business purposes? So the point is, a lot of activity in this as a consequence of some of these great rules.
We're going to leave people with more questions than answers, but that's good. That's good.
That's good.
Miriam, could you check, Idul Investors, you've invested in a lot of startups, wide range of stages and varied levels of lots of success, some success, less success. Have you taken advantage of secondary markets? Has that been something that you focused on? And what's been the consequence?
I have not, mostly because I consider myself a long-term investor. I am trying to invest in companies that I think are going to be potential billion-dollar companies. Many of my companies have been subsequently financed by, the Sequoias and the Kleiners of the world, and I'm betting that they will help those companies to grow into quite large companies. But I have definitely been offered the ability to sell my shares through secondary markets, like a site. The secondary market site, for example, currently has a tender offer of SoFi stock. And my sense is that the price differential between the common and the preferred is quite small on that one. I'm assuming that means that a lot of the common stockholders will want to sell. And, it may also help provide for some companies as they move to going public, maybe that closing that differential is part of avoiding a cheap stock problem. So maybe that is a helpful part of having a secondary market. In terms of the ways that it's more typically done, I would say that as a new round of financing gets done, oftentimes the new investors will offer via the company to buy the shares of prior investors. And so it tends to be a privately done transaction at the valuation that the next round is buying. But we do get calls from time to time from wealth managers for private individuals who are looking for specific companies, and to the extent that you get affiliated in the press with a particular company, like a Palantir in my case, you get a lot of random calls.
Mm-hmm. So let me maybe direct a question at Keith that builds on this thinking, and that is now with the increased flexibility with regards to what isn't counted under the shareholder limit on the Exchange Act for employees' purposes. You've got these longer timelines. What can companies do to handle the liquidity needs of employees who want to sell their shares, and what's some of the thinking that you recommend on the part of these issuers?
Yeah, of course, we in the division don't recommend anything, but the things we've seen.
I tried.
And things that we have seen, obviously, particularly for employees. Larry mentioned that where you held the stock for at least a year, you can freely sell without any restrictions. On the other hand, for employee options, that holding period doesn't start running until the employee exercises the option. And so that's a problem because you also have a tax event when the employee exercises the option, needs to come up with the exercise price and pay the tax. So you need to be able to sell immediately. And so we just had a presentation, the Advisory Committee on Small Emerging Companies had a presentation from Anne-Marie Tierney, who I'm sure many of you know from Second Market, whose company is involved in helping other companies do tender offers for employee and other shareholder stocks where they will, they'll either the company will do a tender or a third party will do a tender for a block of securities offered to pay a particular price for all the securities that are offered. This provides liquidity. We understand in those situations, at least according to Anne-Marie, that issuers tend to provide financial information, so that both buyers and sellers have access to information. That's one thing from the commission standpoint that we're concerned about private markets is the lack of transparency. The one thing about public markets is that companies are filing their reports and you have financial information. With the absence of financial information, it makes it tough both for buyers and for sellers to make decisions. But we're looking at various ways of secondary liquidity where there's talk about venture exchanges, there's talk about institutionalizing the 4A 1.5 exemption. So there's a lot of activity on our plate.
So I'm going to skip to our last question because I don't want to leave crowdfunding not addressed at all, but I'll plant two items. I think, Larry, you already mentioned that you don't get a pass under all these changes around the anti-fraud provisions, and that's worth thinking about, so maybe we'll get some questions or a chance to address it. And then I want to plant a question that we might come back to, which is, if employees are selling, are there some complex or nuanced obligations on the part of the company if you worry that the employees are selling too cheaply in some cases, and that kind of comes back around. But the question I have is, SEC has proposed rules under crowdfunding provisions for the Jobs Act. Assuming the proposed rules are adopted, and you can make different assumptions about how that happens, but one way or another, if adopted, what impact do you think the rules will really have on fundraising in the Valley? And I'd invite both Larry and Miriam maybe just to give us like a 1 minute or 2 minute view of that.
My view is not going to have a major impact. I think it really has a risk, and that it's going to be ventures that can't get financed. And therefore, it's going to go to the lowest common denominator, and that is the retail investor who's thrilled with the idea of buying a Silicon Valley startup stock, and that the risk of failure is enormously high. It's only $1 million, and it really is only $1 million because if you do another exempt offering, it may be integrated with it, so you blow the exemption. It is true that you have to use an intermediary that's registered with the SEC. There are disclosure obligations the staff is going to propose, so it's not a cost-free approach. So I worry about it. You know, oftentimes we relied upon the intrastate offering exemption, which allows you to sell securities to residents of the jurisdiction where you do business and incorporate it, provided that the offering comes to rest in the state. There you can have general solicitation. There you don't need accredited investors. There you can have a large number of offerees. And I just wonder whether crowdfunding is going to go a step too far, and we end up with really unhappy investors who are really ill-informed. However, there is a place for it. I mean, I'm not saying it's not a bad thing. I just think for tech startups that have to scale and have so many inherent risks in them, it's not like a hardware store raising money or someone raising a small business like a floral shop where the risks are more known. These are the troubles with the crowdfunding. I have an open mind to it, but I think we need more work at it.
Miriam, last word on that, and then we'll switch to some questions.
I guess I'm a bit more open to the notion of crowdfunding from a variety of perspectives. So when I was an investor in a company called ProFounder that was actually trying to let your mom and pop businesses be able to finance using in compliance with the state regulations. That was shut down in part because they were ahead of their time. A lot of the things that they did are now going to be permitted under the Jobs Act. I certainly think that there are mechanisms, at least that are proposed right now, that actually provide greater protections for investors than some of what you get in the real world of Silicon Valley. So, the updating annually the investors with financial information. If you're an investor in Silicon Valley and you don't happen to be a major investor, you may have absolutely no information rights to the point of a company going public. And I think that's a pretty common phenomenon here. So my sense is that in some ways it may be more protective than what currently exists as a status quo. I certainly think that the status quo is acceptable in Silicon Valley in part because there is such a high level of sophistication in the investor pool here, whereas I think that more protections may be needed in crowdfunded sites. However, I'm also, as a person that would potentially back a company that wants to get into the crowdfunding space, I think that there are potential problems with regulation that might make the websites liable for the activity on their site. And I think that we probably need something a bit more like a DMCA for crowdfunding sites so that there's some sort of safe harbors if activities that become known as illegal or companies that are doing activities that would be fraudulent should be able to be taken down and not permitted to run their fundraising on a particular site, but trying to make the company itself liable for the actions of a lot of people online is something I'm less comfortable with, and I think that there are other ways that can be addressed.
So we have 5 or 6 minutes left, which is probably just enough time to ask 1 or 2 questions. If you have a question, we've got plenty more, by the way, so don't feel obligated. But if you have a question, please come up to the microphones. We do have, it's not often you have Division of Enforcement, Division of Corporation Finance, right here, able to answer your questions. And if not, we've got a couple more. All right.
Given that lawyers, outside firms, often are the gatekeepers to helping the SEC police fundraising, but given what you said about the vagueness of reasonable procedures, what does a lawyer have to do to give a legal opinion letter that these procedures under 506B have been met? Can they?
We're all looking at Carlos.
Yeah.
I have not encountered a written lawyer letter, so I have not been in a position to test that. I think Larry's point that, what lawyer would actually do that, the comfort level of that. And then I also worry about the parallel opinion letters by lawyers who help pump and dumps all the time where they clearly have no basis for making the representations they have. So I think we would have to look at that and sort of explore what it is that the lawyer knew. I mean, maybe they have a long-standing client. They, go to a golf club that charges $20,000.
White heart, empty head. Is that a defense?
I don't know. I guess the question would be, would we want to charge the lawyer, or do we want to go after the people who took the lawyer's letter, maybe knowing it wasn't quite on the best ground?
But Carlos, let's remember what the opinion is. The opinion, I assume, is issuer's counsel is giving an opinion to the investor.
Yes. That
the issuer took reasonable steps to verify that the investor was an accredited investor. I mean,
no. That the company had a reason.
Right, that the company had taken reasonable steps to verify that the person to whom the lawyer is giving the opinion was an accredited investor. Larry, I don't know what, and I'm not practicing privately anymore, but I would have thought in that circumstance that a lawyer might say in the opinion letter, for purpose of this letter, we're assuming that the company took reasonable steps. And obviously, if the lawyer didn't believe that the company had taken reasonable steps, he or she couldn't give that opinion. But remember, the opinion is going to the person who is the accredited investor.
Yeah, I'm actually going to jump in. I'm going to make a suggestion because I want to get to two more questions. We're going to hang out here for just a few minutes. So come on up for a moment, and I can't promise that anyone will answer, but I'll stand here. So yeah, no worries. So let's take two more questions. Yeah.
Okay, so when I was growing up, they had the numbers game, which gave you 600 to 1 payoff on 1,000 numbers. So I took algebra in the 7th grade, and I asked people, well, why did you do this? And they said, it's super beta non-correlated return. This was in Jimmy Hoffa's Loco, so these guys were real sophisticated guys. But what happens is it seems like that's what this whole Jobs Act and the crowdfunding is, like Larry says, that a few people will make a bunch of money, but on the overall whole, that there'll be, net losses. This is what the Stanford V Lab said, that they thought that an average person, the average crowd would lose maybe 20 to 40%. And so, because there's just not sophisticated investors, there's not sophisticated businessmen. And you really need an angel group to do it. So it just seems like the Jobs Act really was created to create jobs, not to get the returns. And so it would say that unsophisticated people really got to be really careful investing into companies.
Yeah,
as
people have to realize that
creating jobs.
People have to realize that the venture capital business is a very tough business. They have to realize that the returns in the venture capital business, if you look back over the last 10 years, pale in comparison, which they were when we got this business all started. You have to realize that venture capital is shrinking. How many boards can a venture capitalist be on? The size of the venture capital funds, the size of the money that they've raised is less, all because of risk. And now they're very good people, these venture capitalists. They do their homework, they're very knowledgeable, and if they get a return today of 1.5 to 2x, they're not feeling that bad about it. You drop that expertise out of the system and you go to a crowd fund, of course you're going to increase risks. And that is a concern. And that is a concern I have about what problem are we trying to solve.
Yeah. Okay, thanks.
Last question.
My question is about comparing what the world would look like with some of the regulations that the commissioner was suggesting in the crowdfunding space, like giving a specific investment vehicle similar to like an ETF. That was my understanding for people trying to like invest in a crowdfunding platform for a startup. Like, what would the world look like in comparison between crowdfunding startups and investing in penny stocks? Because we allow for investing in penny stocks, and those are very risky as well. So what's the comparison between those two worlds?
That's a great final question. I'll let whoever wants to jump in give an answer.
No comment.
No comment. Miriam and Larry, I think it's up to you. Unless Keith would like to jump in. Keith? Okay. Yeah. That's fair. Miriam, Larry, what do you think? You're allowed to speculate.
I think we're out of time. I'm not giving that opinion.
I think that was a good question, though.
Well, as they say at the law school, we'll leave that as an exercise for the student. Thank you very much. All right. Thank the panel for me. Thank you very much.
Good job.
Great.